Moving on to an email query next, Mrs. Pereira says that her husband lost his father in 2013. Now, her father-in-law had selected her husband as a nominee of his property in 2004. This is signed by two witnesses. The documents and rent are on her husband's name. However, the society is now asking for an NOC from her sister-in-law for registration. She wants to know if this is compulsory and why it is needed. Vinay, I can see you smiling there. This is one of your favorite questions.
Yes, it is. Because, societies are not aware of the law, secretary, chairman, etc., lay people. So, everyone wants to just cover themselves. If you look at Section 30 of the Maharashtra Cooperative Societies Act, no such NOC is required. You are not required to look into wills or letters of administration. You simply follow the nomination. If you read Section 30, it says that once an application is made, the society has no choice but to transfer it to the nominee without going into the question of who are the legal heirs, etc. So, all you would need to do is fill up the application in the relevant form, pay 100 rupees as your entrance fees. Even the indemnity is not required unless there are multiple nominees. So, in this case, since you said there is only one nominee, even that is not necessary. Just a simple declaration, which is of course mandatory, to say that you will use the flat for the purpose for which it is given to you. That is all that is required. So, just these three things, and the flat should be transferred into your husband's name.
So that's the answer there, Mrs. Pereira. You do not need an NOC from your sister-in-law. However, there is a difference when it comes to inheriting that particular property. Vinay, can you elaborate a little on the difference between the nominee of a property and the heir to a property?
Well, the nominee is holding the property in trust for the real legal heirs. So, if there is a will, then we follow the will. If not, then you follow your personal law. And those are the people who are the real owners of the property, who have the title. The nominee, of course, in this case, would be at least one of the people who has a share in the property. So, if you need to transfer legally, you want to will it to, transfer it to somebody, you need to make a will. A nomination by itself is not sufficient, and that is something everyone should remember.
Right. So that's a key takeaway coming for all of you right on top of the show. A nominee is not an heir. A nominee and heir are two different things. A nominee is merely a trustee for the property, and the property in a housing society, if you have a nominee, after your death, the property passes on to the nominee. However, when it comes to inheriting property, you need to have a will. And if there is no will, then the personal law that is based on the religion that you follow will be followed in this regard. So that is something that you need to keep in mind. Nominee and heir are two different things.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.